Hi, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with utilities and due diligence. So if you are showing a property and the utilities are not on and your buyer likes the property, make sure to include a special stipulation in your contract regarding the seller's obligation to turn the utilities on. GAR contracts have a special stipulation. It's Special Stip 331, Utilities Due Diligence to Begin. And this is what it says. Notwithstanding any provision to the contrary contained herein, the due diligence period shall commence on the date that the seller notifies the buyer that the following utility services servicing the property have been turned on and billing accounts have been established. Herein after collectively referred to as utility activation. Then you have a check mark for water, public sewer, electric, and gas. In the event utility activation has not occurred within blank days from the binding agreement date, buyer shall have the right upon notice to the seller to terminate this agreement. So in the GAR contract, it has in there that the seller is responsible for turning on the utilities. In the RE Forms contract, there is a fill in the blank where the parties negotiate either the buyer or the seller is responsible for those utilities. But you as a showing agent know when you're going through the house, check everything. Check the gas, check the water, check the sewer, check the electric, and if they aren't on, absolutely make sure that those are on, because what's going to happen if you don't address it up front, the utilities will never be turned on and the buyer is going to run out of their due diligence period and they're just going to have to terminate without that provision of having the seller turn them on. There was a contract where it was binding under the GAR form, so the seller was obligated to turn on the utilities. Seller never turned them on. Buyer's agent never approached it. Basically what happened is the buyer failed to come to closing. So buyer defaulted on the contract, and in the research regarding what happened, it was determined that the seller failed to turn on the utilities. The buyer had foregone an inspection, so the buyer never went to have it inspected or looked at or anything like that. But the appraiser could not do the appraisal because the utilities had not been turned on. Therefore, the buyer was denied the loan because there was no appraisal done, and so forth and so on. Instead of the buyer's agent terminating under either the appraisal contingency or within the financing contingency time frame or prior to due diligence ending, the buyer just failed to show up to closing. And in the research, when asked, well, why did the buyer not come to closing, the buyer's agent said, well, the loan was denied, therefore what's the reason of going to closing? Well, the buyer can't just do that. The buyer cannot just fail to show up to closing. Yes, the seller did not live up to their term of the contract to have the utilities on, but the remedy of that is not a buyer failing to close. There are other built-in remedies for that. One of them is the buyer's obligation to terminate under due diligence and protect their earnest money. Secondly, as I just mentioned, handling it within the financing contingency time frame and the appraisal contingency time frame. So again, you guys know when you're going through the house, check all the utilities, address that issue up front in the offer. So hope that helped. And again, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.